Thank you, Chief Justice, colleagues and counsel. My judgment is 149 pages. I will greatly summarize it for purposes of this delivery. And there's a presumption that all counsel can read. So please do read it, because other teachers of law tell me that counsel hardly read judgments these days. Please try and read these ones. 2, I have read the judgment of the Chief Justice and President of this court, and I will adapt it for purpose of my judgment. I also agree with their reasoning and findings, save where I shall express myself to the contrary. In that context, when the Kenyan people gave themselves the Constitution 2010, it was a matter of public knowledge that certain parts of it would require amendments at some point in the future. There was, however, no agreement as to what these parts were, and it was left to a political class to raise a number of issues over the years that debatably required amendment. Third Way Alliance, for example, initiated the Punguza Mizigo, Lighten the Burden initiative at a referendum on a number of issues. That initiative failed. I have therefore taken into account the pleadings, the submissions, and my opinion on each issue is summarized as follows. On issue number 1, I delved into the history, the genesis and history of the basic structure doctrine. Like my colleagues before me, I looked at Kesavananda at length and the history of Kesavananda and the findings in Kesavananda. I also delved in the history of Article 257 on amendments through a popular initiative as opposed to legislative amendment under Article 256. I specifically looked through the CKRC reports, and in the final report, I reproduced sections, page 75, where the Commission said this: a distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being set up for amending the former entrenched provisions, which should include supremacy of the Constitution, the Bill of Rights, land, the judiciary, security, finance, and the system of government. The final report then came up with the following recommendations. I'll only pick on 2. Recommendation number A: the new Constitution should have some entrenched provisions, for example, human rights, that Parliament does not have power to amend. And Roman D2, the entrenched provisions should include the procedure on amending the Constitution itself, the provisions establishing the Republic of Kenya, the provisions of sovereignty of the people, the provisions on supremacy of the Constitution, the Bill of Rights, the separation of powers, provisions on existence and powers of independent commissions and bodies. Those proposals by CKRC are important because, like Professor Migai Akech, amicus curiae, I have said that the above recommendations are what morphed into Chapter 16 of the 2010 Constitution, and by those provisions, the people attained the right balance between constitutional flexibility and rigidity and provided sufficient and strong safeguards against the culture of hyper-amendability that characterized the Independence Constitution. Chapter 19, in fact, of the Boas draft and Chapter 19 of the Wako draft are also identical as to what's contained in Chapter 16 of the Constitution today. History has shown us that the people did not intend to immunize the 2010 Constitution. To the contrary, they envisioned that they could amend the provisions of that Constitution through exercise of secondary constituent power, provided that the amendment procedure under Chapter 16 is strictly observed. If the people wanted to entrench provisions other than those set out under Article 255(1) or to immunize any of the provisions of the Constitution, they would have done so expressly. It is therefore correct to say that courts should not, by judicial craft or innovation, impose hurdles to prevent the people from amending the Constitution, provided that procedural requirements under Chapter 16 are complied with. In my judgment, I made reference to my own decision in Commission for the Implementation of the Constitution versus the National Assembly of Kenya and 2 others. I had counsel in this court say that that was the introduction of the basic structure doctrine by courts in Kenya. That is not anything near the truth. That judgment was addressing amendments by Parliament to Article 260 of the Constitution in order to remove the office of members of Parliament, members of county assemblies, judges and magistrates from the list of designated officers under that article. The dispute, much like a Savananda, related to the amendment power donated to Parliament. And going to the 4 sequential steps, I've said those processes are indeed relevant and useful, not in amendment under Chapter 16, but amendments, but making of the Constitution, should we as a country ever decide again to dwell with the present constitutional order and create a new one. And therefore, in summary, on issue number 1, my finding is that the basic structure doctrine does not apply in Kenya in the manner suggested by the 1st to the 5th respondents, and that the 4 sequential steps set out by the High Court and the majority of the Court of Appeal only apply when a new constitution is being made and not in any amendment process under Article 257. In addition, based on our history, the text of our Constitution, and the context as outlined in my judgment, it is legislation such as the CKRC Act 2008 and 1997 that the 4 sequential steps should be anchored when and if the people ever want to change the present constitutional order. Those are my findings on issue number 1. On issue number 2, I have read the Chief Justice's judgment. I have looked into the history of Article 257. And if you look at the CKRC reports, Article 257 was intended to be exercised by the common man and civil society, and not anyone outside that category. I have therefore no hesitation in holding that the President cannot and should not initiate amendments to the Constitution under Article 257. Like George J.A., I'm certain that popular initiative is people-centric, and while the President has certain rights as a citizen, there are certain other things that are curtailed by the Constitution as regards him. The President cannot initiate the process by collecting 1 million signatures and crafting an amendment bill, and then retire to await the same bill under Articles 257(9) and assent to it as President. That is an absurdity that could not have been the intention of the framers. Neither can he initiate a bill under Article 256(5)(a), and then under B, request the IEC conduct within 90 days a national referendum for approval of the bill, and then retire to assent to it as a President. And therefore, my finding is that he cannot initiate a popular amendment under Article 255. But I've said, knowing the politics of this country, if the President has parliamentary muscle, he can then invoke Article 256 and initiate amendments through Parliament. On the second limb of this question, I have disagreed with my colleagues. My finding is that there are 2 processes involved in this whole situation. The first process is the presidential political process, which ends with the creation of the steering committee. And then there is the process under 257(1), which is the process of the secretariat led by Junet Mohammed and Dennis Waweru. And I've said that if you look at 257 properly, the process begins with the signature collection and creation and a drafting of the bill or suggestion. And that process was only undertaken by Dennis Waweru and Junet Mohammed, and there is no place in which I have found in the record the role of the president. And therefore, on that narrow issue, I have disagreed with the Chief Justice. On the second schedule of the Constitution of Kenya, whether it's unconstitutional, I have looked at Article 89(1), and I have said you cannot, as that was done by the initiators and promoters, purport to amend Article 89(1), leave Article 89(2) to Article 89(12) untouched, and then purport to bring this amendment bill and create new constituencies without involvement of the IEBC and the people, especially those who would be affected by the creation of new constituencies. Boundaries of constituencies are a very emotive question in Kenya, and that is precisely why Section 89 is very elaborate as to the procedure to be undertaken when new constituencies are being created. And therefore, for those reasons, and for the reasons given by the Chief Justice, I've agreed that that schedule is unconstitutional. But I've said something a little more. Let those who wish to create new constituencies follow the process under 89. Do not ignore IEBC, don't ignore the people, and if you wish to start the process within Article 89, you are permitted to do that, but do not go outside the remit and permits of Article 89. That takes me to issue number 4, proceedings against the President. I agree with the Chief Justice on this question, and I've also addressed the remedy of impeachment of the President should there be a violation of the Constitution. I've also addressed my judgment in the High Court in the Isaac Aluochir case on representation of the President by the Attorney General when the President is sued in his personal name. I have said that the President cannot be sued in his personal name for violations of the Constitution, and should he be sued for whatever reason, then the proper respondent should be the Attorney General and not the President in his personal capacity. I had lawyers for the President pray for costs in favor of the President for having been properly sued in his private capacity in this case. While I agree with them that such an order would have been efficacious, in fact, the nature of this particular litigation being in the public interest, I would not grant the President orders of costs, despite my findings in his favor. On issue number 5, public participation by the IEBC and the initiators and promoters of the bill, I have looked at the BAT case, a recent decision of this court. I've also looked at Justice Pauline Nyamoya's judgment in Republic versus County Assembly of Kirinyaga, and I've agreed with the judge that in processes under 257, there are certain rules attributed both to IEBC and to the initiators and promoters. Looking at the stage at which the IEBC was stopped, or the whole process was stopped, it is very difficult for me to say that public participation was not sufficient. In fact, the two most important public participation elements in a popular initiative are voter education by IEBC and popularization of the bill by the promoters. None of these processes had been reached by the time the High Court stopped the process. A last issue on this point is this. Gatembu Kairu and Tuyot raised a fundamental question. Why are we as a country still struggling with lack of a legal framework to govern processes under Article 257? There is no law on collection of signatures. There is no law verification of those signatures. There is no law on how county assemblies should pass the amendment bill, the processes by Parliament despite the standing orders, the receipt of the bill by the President, transmission of the bill to the President, the referendum. I have said it is about time to avoid the confusion that I'll address shortly as I address issue number 6 and 7, that we need a law. And so I agree with Justice Tuyot and Justice Kairu that this law is absolutely necessary. And therefore, the second schedule, in my mind, is an exception. The public participation processes were properly undertaken, save for the second schedule, where I have said that it's unconstitutional for the reasons that I've given. Articles 88 and 250 with regard to composition and quorum of the IEBC. I have looked in my judgment at the Katiba case by Chacha Mwita J. I have looked at the Isaiah Biwott case by Frida Okwan J. I have looked at Article 250, sub-Article 1. I have taken into account the very lucid submissions by Esther Angawa regarding Article 88.5, and I have said that, to my mind, looking at the law as I understand it, IEBC was correct at all material times, its processes were lawful, and therefore a contrary finding would, in my view, be in error. There was a second issue raised by Ms. Kituku regarding nullification of the laws. Well argued as the point was and lucid as the arguments were, I have declined the invitation to address that question because once I found IEBC correct, other matters are irrelevant. The last issue is issue number 7 on the proposals, whether proposed amendments should be submitted as separate and distinct referendum questions. Like the Chief Justice, I have looked at the law of ripeness and mootness, I have looked at the law on justiciability, and I have come to the firm conclusion, like Justice Tuyot, that this question was premature. IEBC had not had the opportunity to exercise its mandate as the body to conduct the referendum, to draft the question or questions, and I've said only this as regards that mandate. Section 49 of the Elections Act and Article 257 do not sit well together. And I've asked IEBC to, as they reconsider this question, to look at Section 49 of the Act and Article 257, harmonize the language. I've shown why, in my judgment, why there's a problem with that issue. And only then would any party with a dispute go to court once the IEBC has determined the matter within its mandate. Once courts start taking off the mandates of independent commissions, we shall walk into a minefield. And therefore, in conclusion, summary of my findings are as follows. On the basic structure is my finding that the doctrine as enunciated in the Savanada case has not attained wide acceptability and cannot certainly be applicable to Kenya, noting our history, context, and constitutional text. The 4 sequential steps identified by the High Court as necessary in an amendment process are also not applicable, save in the creation of a new constitutional order, which is not the case in this dispute. Number 2, on whether the President can initiate a popular initiative to amend the Constitution Article 257, it is my finding that he cannot, but I've said also that in this particular dispute, he did not. On whether the second schedule of the Constitution is unconstitutional and purported to limit boundaries without the input of IEBC, without amending Article 89, 1 to 12, without involving affected persons and the public at large, I have held that it is indeed unconstitutional. Can civil proceedings be instituted against the President during the term of office? I have said no. And should he be sued, then the proceedings should be against the Attorney General, and any remedy for a suit directly against the President should lie in costs awardable to the President. On public participation, at the time the High Court stopped the process, I cannot find reason to fault either IEBC or the initiators and promoters, with the exception of the second schedule, which are found to be unconstitutional for inter alia lack of public participation. On the quorum of IEBC at all material times, I find that IEBC was correct and all its undertakings were lawful. On the question whether a referendum, single multiple questions should put the people by IEBC, I find the matter was premature and was not ripe for determination. On costs, the public interest exhibited in this matter will lead me to the conclusion that each party should bear its cost. My reasons in detail are contained in my judgment, which you shall get copies of. I thank you, Chief Justice. I thank you, Counsel.
Thank you, Honorable Mr. Justice Lenaola, for rendering your opinion. I will now call upon Lady Justice